Hello students, my name is Abhishek Sudhir and I am an assistant professor at the Jindal Global Law School. Welcome to the UGC's EPG Pathshala project. Today we will be dealing with paper number 4 on civil and political rights, module number 24, judicial pronouncements on the rights of prisoners in India. The state in India is under an obligation to protect the human rights of its citizens as well as to protect the society at large, and is authorized to do so by the Constitution of India. To protect its citizens from any possible abuse of this authority, they are given certain basic privileges recognized by the Constitution. Elevation of such claims to the status of rights gives the citizens the capacity to evoke the power of the judiciary to protect them against violation of such rights by the state, as well as to seek redressal. The Indian freedom movement played a crucial role in initiating the process of identifying certain rights for prisoners. After independence, the Constitution of India conferred a number of fundamental rights upon its citizens. It's worth noting at this stage that many of India's freedom fighters themselves were prisoners for long periods of time, sometimes stretching into years, like Jawaharlal Nehru and Subhash Chandra Bose and Mahatma Gandhi, to name a few. Article 21 of the Constitution guarantees the right of personal liberty and thereby prohibits any inhuman, cruel, or degrading treatment to any person, whether he is a national or a foreigner, or for that matter, whether he is a prisoner or not a prisoner. Right? This was the landmark holding in the case of Maneka Gandhi, which we will shortly come to in this module. In this module, we will also look at the judicial pronouncements on the rights of prisoners and take in landmark cases like Sunil Batra, Francis Coralie, basically. Alright, so what are the learning outcomes of this module? After studying this module, the student will understand how the Indian judiciary has shaped the law dealing with rights of prisoners. Right? The student will have an appreciation for the efforts of the judiciary, which has zealously guarded the rights of prisoners over the decades. So what is the legal framework in India on prisoners' rights? We've covered a lot of this in module 23, so please go have a look at that if you've not yet done so. Here in module 24, we deal with the judicial interpretation of the laws, basically. The main act as far as prisoners' rights are concerned, which we've already dealt with in a previous module, is the Prison Act of 1894. Any excess committed by a prison authority on a prisoner, right, not only attracts the attention of the legislature but also the judiciary. The Indian judiciary, and obviously the Supreme Court in particular in the recent past, has been very vigilant against violations of human rights of the prisoners. Of human rights of prisoners, basically. A series of news items appeared in the Indian Express in the 1970s about the continued incarceration of under trials in Bihar. Some of them were never produced before the court. Some others had spent more time in jails as under trials, and the maximum penalty that could be imposed upon them if they're convicted of the offense they were charged with. Essentially, the plight of under trials in Bihar was the catalyst for the movement to bolster the rights of prisoners in India. The Supreme Court issued a writ of habeas corpus for under trials, basically. The writ of habeas corpus means you shall produce the body. We will come to this writ later in this module. The Supreme Court has stated there can be little doubt after the dynamic interpretations placed by this court on Article 21 in Maneka Gandhi versus Union of India that a procedure which keeps a large number of people behind bars without trial so long cannot possibly be regarded as reasonable, just, or fair, so as to be in conflict with the requirement of the article, essentially, so as not to be in conflict with the requirement of the article. What that basically means, the court is trying to say, is that under trials, basically, right, when you keep them in prison for such an extended period of time in prison, that violates the right under Article 21, which prevents cruel, inhuman, and degrading treatment, right, and it also violates the procedure established by law. The procedure established by law must be reasonable and not arbitrary or capricious, basically. So, essentially, the Supreme Court early on, like in the 70s, right, recognized the need for reform and the need to actually lay down explicit rights of prisoners in India. The need for prison reforms, therefore, has come into sharp focus during the last 3 to 4 decades. The Supreme Court and the High Courts have commented upon the deplorable conditions prevailing inside the prisons, resulting in violation of prisoners' rights. Prisoners' rights have become an important item in the agenda for prison reform. So the Supreme Court's activism must be noted. The Indian Supreme Court has been active in responding to human rights violations in India's jails and has in the process recognized a number of rights of prisoners by interpreting Article 21, right to life and liberty, Article 19, freedom of speech and expression, Article 22 relating to preventive detention, Article 32 relating to the right to approach the Supreme Court for redressal, Article 37 and 39 of the Constitution dealing with equal justice and free legal aid, basically. Given the Supreme Court's overarching authority, these newly recognized rights of prisoners are binding on the state under Article 144 of the Constitution of India, which provides that the law declared by the Supreme Court shall be binding on all courts within the territory of India. Now we come to some specific judicial pronouncements on the rights of prisoners in India. The following are the reasons cited in various case laws for which prisoners' rights were recognized and upheld by the Indian judiciary. Convicts are not by mere reason of the conviction denuded of all the fundamental rights which they otherwise possess. This was what Justice Krishna Iyer said in the landmark case of Sunil Batra versus Delhi administration, which we'll come to shortly. So essentially, Justice Krishna Iyer is trying to say, just because somebody is convicted, just because someone has committed an offense, is now serving a sentence of imprisonment, doesn't mean that they're no longer human beings, doesn't mean that they no longer have basic rights that are guaranteed to their fellow citizens, their fellow brethren, under the Constitution of India. Like you and me, prisoners are also human beings. Hence, all such rights, except those that are taken away in the legitimate process of incarceration, shall remain with the prisoner. These include rights that are related to the protection of basic human dignity, as well as those for the development of the prisoner into a better human being. This was what the Supreme Court said in the case of Charles Sobraj, known as the Bikini Killer, right? So essentially, what is the Supreme Court saying? They're saying that prisoners are human beings, right? Their rights, except those that are taken away as a result, as a consequence of legitimate incarceration, will remain, basically, right? And these rights include the right to their protection of dignity, as well as those rights necessary for the development of the prisoner into a better human being. The court has also said that if a person commits any crime, it does not mean that by committing a crime, he or she ceases to be a human being, and that he or she can be deprived of those aspects of life which constitutes human dignity. Quite repetitive, but so important that it's worth repeating. It is increasingly being recognized that a citizen does not cease to be a citizen merely because he has become a prisoner. So you continue to be a citizen. The convicted persons go to prison as punishment and not, right, essentially, go to prisons as punishment and not for punishment. Right? Very, very, very subtle distinction there. A convicted person is sent to prison because it's punishment. He is not sent to prison for punishment. Right? The punishment, right, of being deprived of your liberty, of being sent to a prison is enough. You should not be subject to further punishment when you're in prison. That adds on to your sentence, basically. The prison sentence has to be carried out as per the court's orders, and no additional punishment can be inflicted by the prison authorities without prior sanction. This is what the Supreme Court said in the landmark case of Sunil Batra versus Delhi administration. Prisoners depend on prison authorities for almost all their day-to-day needs, and the state possesses control over their life and liberty. The mechanism of right springs up to prevent the authorities from abusing their power. Prison authorities have to be, therefore, accountable for the manner in which they exercise their custody over persons in their care, especially as regards their wide discretionary power. Because with great discretion always comes great power, right? And with power, there is always the possibility of that power being abused, especially by prison authorities. Therefore, it's extremely necessary to have strict enforcement mechanisms, right? You have the judiciary and the executive giving effect, in essence, to the laws passed by the legislature. Now, imprisonment as punishment is now rethought of as rehabilitative punishment. This involves a philosophy that individuals are incarcerated so that they have an opportunity to learn alternative behaviors to curb their deviant lifestyles. Correction, therefore, is a system designed to correct those traits that result in criminal behavior. The rehabilitative model argues that the purpose of incarceration is to reform inmates through educational, training, and counseling programs. This development and growth requires certain human rights without which no reformation, takes place. Disturbing conditions in the prison and violation of the basic human rights such as custodial deaths, physical violence, torture, police excess, degrading treatment, custodial rape, poor quality of food, lack of water supply, poor health system support, not producing the prisoners in court, unjustified prolonged incarceration, forced labor, and other problems observed by the apex court have led to judicial activism, essentially. Right? So, what are some of these disturbing conditions? Right? Physical violence and torture, custodial deaths, excesses on behalf of the police, right? Degrading treatment, essentially, solitary confinement, although which is permitted under the Prisons Act, right? Misuse of solitary confinement, forced labor, essentially, right? Lack of space to sleep in the cells. We'll come to all of this in further detail shortly, right? All of this has led to the Supreme Court to essentially step in. Overcrowded prisons, prolonged detention of under trial prisoners, unsatisfactory living conditions, and allegations of indifferent and even inhuman behavior by prison staff has repeatedly attracted the attention of critics over the years. Unfortunately, little has changed. This was exactly what the Justice Mullah Committee had to say. There have been no worthwhile reforms, said the committee, affecting the basic issues that are relevant to prison administration in India. This report was passed in 1983. And quite sadly, in the 30 years since, not much has changed. Rights of the prisoners have been expressed under the Indian Constitution as well as Indian laws governing prison. The Supreme Court and High Court rulings have, however, played a very crucial role in enumerating the rights of prisoners. So now we come to the landmark case of Sunil Batra. Sunil Batra is the case that essentially invented the PIL remedy, the public interest litigation remedy, where the Supreme Court stated that a member of society or a class of members of society who are oppressed, economically disadvantaged, and cannot approach the Supreme Court, a petition may be filed on behalf of them by an individual. Now, what happened in Sunil Batra? The judgment there was written by the great jurist Justice V.R. Krishna Iyer, who enumerated the basic human rights of the prisoners. Mr. Sunil Batra had written a letter from Tihar jail in Delhi to the Supreme Court providing information about the torture and inhuman conditions of the prison, basically. This case has become a landmark case in prison reforms. This case recognized the various rights of prisoners in the most comprehensive manner possible. The judgment held that, and I quote, "No prisoner can be personally subjected to deprivation not necessitated by the fact of incarceration and the sentence of the court. All other freedoms belong to him, to read and write, to exercise and recreation, to meditation and chant, to comforts like protection from extreme cold and heat, to freedom from indignities such as compulsory nudity, forced sodomy, and other such unbearable vulgarity, to movement within the prison campus subject to requirements of discipline and security, to the minimal joys of self-expression, to acquire skills and techniques." A corollary of this ruling is the right to basic minimum needs necessary for the healthy maintenance of the body and development of the human mind. This umbrella of rights would include a right to proper accommodation, hygienic living conditions, a wholesome diet, clothing, bedding, timely medical services, rehabilitative and treatment programs. So essentially, you see, Justice Krishna in his judgment has been so comprehensive. He has covered everything. Most of this is self-explanatory. Most of this we take for granted in our day-to-day lives. Many of you might ask, well, why should prisoners be given rights? Haven't prisoners forfeited their rights? Haven't prisoners, by committing an offense, forfeited their rights? If a prisoner is in prison for murder or for rape or for molestation or for arson or for assault or voluntarily causing hurt by dangerous weapons or means, a brutal crime, right? Why should this person essentially be given rights? Shouldn't this person have forfeited his rights? Is the question you're probably asking. But that being said, you again go back to the purpose of the prison system. Is the purpose of the prison system to rehabilitate? Or is the purpose of the prison system for retribution, basically? Is the purpose of the prison system an eye for an eye? In India, it appears that it's not, right? And the judgments of the Supreme Court, especially Sunil Batra, give effect to the principle of reformation. You cannot expect somebody to be reformed if they are treated like animals, essentially. If they are treated and they are caged, basically. You don't give them clothing. You violate their personal space. Right now, again, the argument is, well, these people have done the same to their victims in cases of offenses against the person. Why should they not be? Why should the same not be done to them? Again, it's not retribution, it's reformation. The hope is that one prisoner being reformed will lead him to influencing another 2 or 3 or 4 people who from committing a crime, right? Again, we take the example of Yaqub Memon, who was executed recently, right? He was known as a model prisoner who was well behaved, who got educational degrees while he was in prison, was a chartered accountant by trade, spoke very good English, and learned and also helped the other inmates in the prison learn how to speak English. He essentially taught them English. So that showed that he was treated with dignity, right? He was not treated in a undignified manner just because he was a terrorist who was convicted in the Bombay bomb blast. The Indian state, the Supreme Court has said, must ensure basic minimum needs for all the prisoners, right? And once these basic minimum needs are ensured, then the process of reformation can truly begin. If these prisoners don't have a quality or access to a quality standard of life, essentially, right, even a bare minimum standard of life, then the process of reformation, right, the purpose of the prison system, which is reformation, will be completely and utterly frustrated. In Sunil Batra versus Delhi administration, the practice of keeping under trials with convicts in jail was regarded by the Supreme Court as inhumane. The court held that it offended the test of reasonableness in Article 19 and fairness in Article 21. In the Charles Sobraj case, which concerned the punishment of solitary confinement, the Supreme Court regarded it as violative of Article 21 of the Constitution, stating that the liberty to move, mix, mingle, talk, share company with co-prisoners, if substantially curtailed by keeping a prisoner in solitary confinement, would be violative of Article 21 unless the curtailment has the backing of law. Again, the backing of law being the solitary confinement provisions in the Prisons Act, basically, right? So, Sunil Batra did many things, basically, right? They said that you cannot keep under trials with convicted prisoners. See, again, here is the problem. The under trials are presumed innocent, essentially. And when you keep them with convicted, hardened prisoners or criminals, essentially the problem is you make their standard of living very difficult. You make life for them unbearable. And who knows, perhaps if they're completely, who knows, even if they're guilty, they should not be presumed to be guilty and they should not be housed with convicted prisoners. Solitary confinement is an issue that has dogged the Indian prison system because it's an effective means of enforcing discipline, but at the same stage it has a very detrimental impact on the mental health of the prisoner. So in Sunil Batra, the Supreme Court has said that the curtailment of the freedom of the prisoner through solitary confinement is violative of Article 21 unless it has the backing of law, basically. The court also in Sunil Batra's case held that essentially the barbed fetters make a serious inroad on the limited personal liberty which a prisoner is left with, and therefore, before such erosion can be justified, it must have the authority of law, essentially, right? So Sunil Batra even dealt with the aesthetic feel of a prison, how it should look, and said any fetters, etc., should have the backing of law, should be proportional and reasonable. In Sunil Batra, in furtherance of prison reforms, the judges set out guidelines to be prescribed and followed. These guidelines are worth considering in full. The state shall take early steps to prepare in Hindi a prisoner's handbook and circulate copies to bring legal awareness home to the inmates. Periodical jail bulletins stating how improvements and habilitative programs are brought into the prison may create a fellowship which will ease tensions. Prisoners' wallpaper, which will freely ventilate grievances, will also reduce stress. So essentially, they spoke of a wall of democracy, as you have in Delhi University, basically. All of these were to implement the provisions of the Prisons Act. The state should also take steps to keep up to the standard minimum rules for treatment of prisoners recommended by the United Nations, which we've covered in Module 22, especially those relating to work and wages, treatment with dignity, community contact, and correctional strategies. The Prisons Act needs rehabilitation and the prison manual total overhaul. Even the model manual being out of focus with the healing goals of a reformative system. A correctional orientation course is necessary for prison staff to inculcate constitutional values and teach them therapeutic approaches and to help them master the art of tension-free management. So now let's come to the very important topic of legal aid to prisoners. Prisoners' rights shall be protected by the court by its writ jurisdiction plus contempt power. What does that mean? The court has a writ jurisdiction. There are various writs like habeas corpus, mandamus, certiorari, quo warranto. Right? The writ we really will be dealing with here is the writ of habeas corpus. Habeas corpus means produce the body, and legally, and the rights of prisoners shall also be enforced through contempt power. So when the court lays down certain orders, certain rules, certain guidelines, if they are violated by the prison authorities, they will be in contempt of court and therefore will be punished under the Contempt of Courts Act, basically. To make this jurisdiction, writ jurisdiction, visible, free legal services to the prisoners shall be promoted by professional organizations recognized by the court, such as the Free Legal Aid Supreme Court Society. The district bar shall, the court recommended, Supreme Court has recommended, keep a cell for prisoner relief even. So there is a cell for prisoner relief. So essentially, there is a writ jurisdiction and there is a contempt power that the court holds. For this to be effectively enforced, free legal aid is the need of the hour. And this free legal aid, the responsibility lies essentially on the Legal Services Authority Act right now, basically. And the district bar also should keep a cell for prisoner relief. The Supreme Court has given a new dimension to the writ of habeas corpus, basically, through its judgment in the Sunil Batra case. The habeas corpus writ was traditionally used for securing the release of a prisoner detained illegally. Habeas corpus, as I've told you, means you shall produce the body, which means you will produce the prisoner, basically. It is a favored remedy because of its simplicity, non-technicality, and the priority which is given to its hearing by courts. The writ of habeas corpus must be prioritized by the courts because it is the personal freedom, the personal liberty of an individual which is at stake. The second case of Sunil Batra 2 versus Delhi administration, right, lays down the important principle of law that a writ of habeas corpus is available not only to secure the release of a prisoner illegally detained, but also to regulate the conditions and manner of detention of a person whose detention is lawful. Thus, a speedy and simple remedy is available to prisoners to seek redressal of their grievances about the manner of their detention. Prisoners now have an important forum for the enforcement of their rights. That's the Supreme Court. As all the grievances could formally be aired only through the prison hierarchy, very few prisoners voiced any complaints for fear of retaliation from the prison authorities. The very existence of the remedy of a writ of habeas corpus would be a deterrent to jail authorities and could prevent arbitrary and capricious action. Now we come to the landmark case of Francis Coralie. In Francis Coralie, right, essentially, the Supreme Court explained the ingredients of personal liberty under Article 21. The case of Francis Coralie arose out of the rights of a detainee to have an interview with his or her family members and lawyers. The meeting of family members under a statute was restricted to once a month, and the lawyer could be met only in the presence of an officer of the Customs Department, essentially. Right? So essentially, if you were convicted under this act, right, you could only meet with your lawyer in the presence of a customs officer, and you could only meet with your family once a month. So, in Francis Coralie, the Supreme Court ruled that the right to life and liberty included the right to live with human dignity, and therefore a detainee would be entitled to have interviews with family members, friends, and lawyers without these severe restrictions. So now we come to the right to compensation for violation of rights. This is a landmark remedy devised by the Supreme Court, whereby the Supreme Court can monetarily punish the state for essentially violating the rights of prisoners. Monetary penalties are perhaps the best method of enforcing rights. And though pretty draconian, right, they will be used only in exceptional circumstances. The landmark judgment on the right to compensation for violation of rights of prisoners by the judiciary is the right to compensation in cases of illegal deprivation of personal liberty. The Rudal Shah case, basically. Rudal Shah versus State of Bihar. Rudal Shah versus State of Bihar is an instance of breakthrough in human rights jurisprudence. The petitioner Rudal Shah was detained illegally in prison for more than 14 years. He filed a habeas corpus petition before the court for his immediate release and inter alia prayed for his rehabilitation, cost, medical charges, and the compensation for his illegal detention for all those years. After his release, the question before the court was whether, in exercise of its jurisdiction under Article 32, whether they could actually pass an order for payment of money. Right? Article 32 allows the citizen to enforce the Supreme Court for the enforcement of his constitutionally guaranteed rights. So the Supreme Court had to consider in Rudal Shah versus State of Bihar whether they could make an order for payment of money against the state, an order for compensation, whereby the state would compensate the under trial prisoner for being held for 14 years. Was such an order in the nature of compensation consequential upon the deprivation of fundamental right, was the question the court had to consider. They had to consider whether there was a nexus between the violation of the right and the power to award compensation. There is no express provision in the Constitution of India for grant of compensation for violation of fundamental right to life and liberty. However, that did not stop the Supreme Court in Rudal Shah. The judiciary evolved a right to compensation in cases of illegal deprivation. The court granted monetary compensation of Rs 35,000 against the Bihar government for keeping Rudal Shah in illegal detention for 14 years even after his acquittal. This highlights the sad state of affairs in the state of Bihar, whereby an individual, even after being acquitted, not even an under trial, but even after being acquitted, was held for 14 years and held illegally. This is the sad part about the Constitution of India. Essentially, though it is a fabulously written and drafted document, very few common people have a knowledge of its provisions, let alone the Constitution. People don't even have the understanding that once they've been acquitted, they have a right to be released. Rudal Shah lost 14 years of his life. The Supreme Court felt that it had to do something about this. It therefore ordered the state of Bihar to pay Rs 35,000 in compensation to Rudal Shah, thereby sending a strong message that the violation of prisoners' rights will not be taken lightly by the highest court in the land. Therefore, the court departed from the traditional approach, ignored the technicalities, and granted Rudal Shah compensation. So what is the importance of the decision of Rudal Shah? The decision in Rudal Shah was important in two respects. Firstly, it held that violations of a constitutional right can give rise to a civil liability enforceable in a civil court. And secondly, it formulated the basis for a theory of liability under which a violation of the right to personal liberty can give rise to civil liability. So essentially in Rudal Shah, what the court said is, Rudal Shah has already been through so much, so we should not expect Rudal Shah now to approach a civil court and ask for damages. We will award him compensation under his writ petition under Article 32. Essentially, and therefore Rudal Shah is nothing short of revolutionary, because once again it makes the enforcement of prisoners' rights that much more easier. And the Supreme Court has, in the last 3 or 4 decades, been willing to go past the letter of the law, been willing to go past the technicalities, and has been willing to look at the spirit of the law, essentially, to give give fundamental rights a definitive content. The decision Rudal Shah focused on extreme concern to protect and preserve the fundamental right of a citizen. Rudal Shah also calls for compensatory jurisprudence for illegal detention in prison. In India, courts have acknowledged and several judgments also have recognized a wide array of fundamental and other rights of prisoners. We'll now come up with a brief table which enumerates the broad categories of rights which are not exhaustive, as this field is still developing and slowly evolving. These rights have been drawn from various case laws. Though these rights are articulated in the case laws, they do not reach the poor prisoners. There are still many rights that are not recognized by the Indian system. So what are the rights that have emerged, the rights of prisoners that have emerged from Indian case law? First, they have the right to be lodged appropriately based on proper classification. They must be based on classification. Are they a death row prisoner? Essentially, are they awaiting execution? Have they been convicted? Are they under trial? Essentially, a special right of young prisoners to be segregated from adult prisoners has also been recognized in various case laws. The rights of women prisoners have also been enumerated, essentially, and courts have encouraged the hiring of more female staff, prison staff. The right to a healthy environment has also been recognized. The right to bail has also been recognized, and as Justice Krishna Iyer put it, the general rule is bail, not jail. In the landmark case of Hussain Ara cartoon, The right to speedy trial was recognized in the judgment of Justice Bhagwati, where he said that you cannot have people languishing in jails for days, months, and years while the trial is being conducted. The right to free legal services was initially recognized by the Supreme Court in various cases, Hussain Ara Khatun again, but was given definitive expression in the Constitution of India and the subsequent passing of the Legal Services Act and the creation of the National Legal Services Authority. They have also recognized the right to basic needs such as food, water, and shelter. The right to have an interview with a lawyer has also been recognized and has been given effect to in the Code of Criminal Procedure, 1973. The right to being against being detained for more than the period of sentence imposed by the court has also been given effect to in the CRPC. The right to protect against being forced into sexual activities, forced sodomy, and things like that have also been given expression. The right against arbitrary use of handcuffs, fetters, chains, and irons has also been recognized by the Supreme Court. And of course, the right against torture, cruel, and degrading punishment, in addition to the right not to be punished with solitary confinement and the right against arbitrary prison punishment. The right to air grievances and an effective remedy has essentially been given to prisoners through the landmark judgments of the Supreme Court, through the writ of Habeas Corpus, and of course the right to be compensated for the violation of fundamental rights, which we have just seen in the case of Rudal Shah. Other miscellaneous rights: the right to visits and access by family members to prisoners, the right to write letters to family members, the right to education in prison, the right to emergency and reasonable health care, a right to information about the rules of the prison, and a right in the context of employment of prisoners, a right to employment and prison wages. So here we've seen in this module that the Supreme Court of India has really been the bulwark against excesses by prison authorities. In conclusion, various judgments passed by Indian courts suggest that they are sensitized to the need for doing justice to the prisoners to whom justice has been denied by a heartless society for generations. Although several judgments have recognized the rights of prisoners, these have resulted in few amendments to legislation, and the Prisons Act of 1894, an ancient act, continues to be in force. It's worth quoting Justice Krishna Iyer to conclude this module. And I quote, "While judicial sensitivity and activism is appreciable, it must be borne in mind that the country's criminal justice system still suffers from substantive and procedural deficiencies. Once a citizen is arrested, even if on a relatively minor charge, he or she could be held in custody for years before his case comes up for trial. Those who are affluent are still being able to negotiate their way around the numerous obstacles that lie on the road to justice. For an ordinary citizen, an encounter with the law is very much the stuff of nightmares. There is a long course before the Indian judiciary to be followed in order to achieve the goal of social justice," unquote. From having almost no rights as prisoners to having almost as many rights as any other citizen of the country, we have come a long way, and courts have been the catalyst in this process, which has ensured that prisoners, while serving their sentence, do not lose their dignity as individuals, and no excesses by prison authorities are inflicted upon them.